Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about Supreme Court. In ancient times, when any wrong was done, it was the king to ensure that the culprit was punished so that the victim gets relief. After the constitution has been adopted, this function of the king has been replaced by the judiciary, whereas the other functions such as making the law and executing them are done by the legislature and the executive. In order to ensure transparency and work in the system, the constitution makers keep these three organs independent of each other. The judiciary is the ultimate interpreter of the rights while it acts as a guardian of the constitution. It can also conduct checks on the legislature and the executive and ensure that no one goes beyond their ambit of power. The constitution ensures that the judiciary remains even-handed in all circumstances. We have different levels of judiciary which is present at the central level, the state level and the district level. In Part 5 of the Constitution, Chapter 4 concerns the Union Judiciary. It consists of the Supreme Court, and in this article, we would be only dealing with the Union Judiciary in depth. Supreme Court. There can be discords arising in between the different units of the Federation, that is, when the Supreme Court comes into play. It is the highest authority and the final interpreter of the law, which means that it has the power to give final decision on all the matters of the law. Its judgments are binding on all the lower courts. It has the power of judicial review through which it can review the actions of the executive and the legislature. Article 124 of the Constitution. The first part of the article provides for the setting up of the Supreme Court, which will be composed of one Chief Justice of India and only 7 judges until the Parliament by law prescribes any more judges. The second part of this article states the Chief Justice of India will be appointed by the President after consulting other judges whom he thinks suitable and will hold the office until he attains the age of 65 years. Whereas the President will have to take into account the Chief Justice's opinion when he appoints the other judges. This article in its part 2A says that a judge can be writing to the President resign from his position, whereas this article in its part 2B says that a judge can be removed under the provision contained in clause 4. Appointment of Chief Justice of India. According to Article 124 clause 2, the Chief Justice of India will be appointed by the President, and in pursuance of that, the President has to consult the judges of the Supreme Court and the High Court which he thinks necessary. The President should also have a warrant regarding it. The provision of the provision for the appointment of Chief Justice experienced many changes during the passage of time. In this article, we will be discussing them in length. Composition of the court. With respect to Article 124, subclause 2, the number of judges was only limited to 7, but the Parliament by law prescribed and amended that the number of judges should be increased to 31, that is 30 judges and the Chief Justice of India. This was done with rationale that if 7 judges will not be able to suffice the work the judiciary undertakes, in order to work efficiently, the number of judges should be increased, otherwise the cases will keep on piling up and there will be more sense of injustice. Appointment of the judges' position before the 99th Amendment of the Constitution. After the adoption of the Constitution, the tradition regarding the appointment of judges was that the senior most judge was chosen as the Chief Justice of India, whereas the Chief Justice of India was consulted by the President, along with some other judges of the High Court and the Supreme Court for the appointment of the judge of these two courts. After some years, this tradition came to an end and the judges were selected according to their merit and not in accordance with their seniority. To illustrate, suppose there is a judge and he has 3 senior judges above him, but the President thinks that he is more capable of taking the position of the Chief Justice of India, so he is appointed, leaving behind the seniority factor. This led the senior most judge to resign from the seats, as the promotion to the designation of the Chief Justice was their aim, and experiencing a judge who is junior to them getting promoted to that post was a disrespect to them. Well, this custom came to an end and the earlier method had to come back when the old government was replaced by a new one. Again, the promotion on the basis of seniority method was reinstated, but the controversy didn't end. The question on the independence of the judiciary started to build up. Supremacy of executive. Judges Transfer 1 case is known as SP Gupta versus Union of India. This case ruled out that whenever there is an issue between the different constitutional agencies, then the decision of the central government will prevail and the government will choose as to which view of the constitutional agency will be taken into consideration. Whereas when the appointment of the Supreme Court judges is concerned with the opinion of the Chief Justice of India, will not be in concurrence and it will be on the government to take the final decision. As far as the word may in Article 124 subsection 2 is concerned, the court stated that it only implies taking decisions regarding which judge of the Supreme Court and the High Court has to be consulted while appointing the judge of the Supreme Court. and High Court, whereas it does not give an option to the government to take into consideration the opinion of the judges. In this case, the supremacy of the executive was maintained.